Welcome to this Q&A session for the Florida Real Estate Sales Associate exam. We'll break down the right answer to each question, show where other options go wrong, and explain the concept behind it. This video works through a complete mixed practice set that spans Florida license law, agency and brokerage duties, titles and legal descriptions, mortgages and appraisal, contracts and settlement. Don't forget, our website offers free study guides and practice questions designed to help you pass the Florida Real Estate Sales Associate exam. Whether you're reviewing key concepts or testing your knowledge, these resources make preparation easier. Just check the link in the description below and start studying smarter, not harder today. Alright, let's dive in. Question 1. A landlord and a tenant in Ocala agree by handshake to a 3-year lease of a small retail space, and neither party ever puts the terms in writing. 6 months later, the tenant walks away. Which of the following best describes whether a Florida court will enforce that agreement? Your options are A. Unenforceable under the Statute of Frauds. B. Enforceable because possession began. C. Void from the moment of agreement. D. Enforceable for the first year only. Which one is it? Pause the video if you need more time. The correct answer is A. Unenforceable under the Statute of Frauds. A is correct because Florida's Statute of Frauds requires a lease longer than 1 year to be in writing and signed by the party being charged. So a spoken 3-year lease cannot be enforced in court. Section 725.01 Florida Statutes. B is wrong because taking possession and paying rent may create a month-to-month tenancy by conduct, but that conduct does not resurrect the long term the parties discussed. The writing requirement still governs those 3 years. C is wrong because void and unenforceable describe two different states. A void agreement has no legal effect from the start, while this one simply cannot be enforced by a court once the other side raises the defense. D is wrong because the statute does not slice a spoken lease into an enforceable first year and an unenforceable remainder. Length of the term the parties actually agreed on is what pushes the whole arrangement into the writing requirement. Centuries ago, English courts faced a problem. A liar with 2 friends could swear away a family's farm in front of a jury. Parliament's answer in 1677 demanded signed writings for the riskiest promises, and Florida still follows that rule today. The rule is narrower than most students think. Only certain deals require a signed writing: sales of land, promises to cover someone else's debt, agreements that cannot finish within a year, and leases longer than 1 year. The deciding factor is never the rent amount or the building type. It is purely the length of the term. A lease of 1 year or less can be sealed with a handshake, but the moment it stretches past 12 months, it must be in writing. Clear up the vocabulary before exam day. A valid contract binds both sides completely. A void agreement never had legal life at all. A voidable contract lets one party escape, as with a minor or a fraud victim. An unenforceable contract is real and fully formed, but a court won't enforce it unless the defendant fails to raise the writing defense. An oral 3-year lease was truly made, but it sits unenforceable, not void, and only becomes enforceable if the defendant forgets to raise the statute as a shield. Question 2. A sales associate in Naples receives a buyer's good faith deposit check on Tuesday morning while presenting an offer at the buyer's kitchen table. She does not return to the brokerage office that day. What is the outside deadline for turning that check over to her employing broker? Your options are A. Immediately before leaving the buyer's home. B. End of the 3rd business day. C. End of the next business day. D. Within 1 week of the offer. Take a second. Which answer would you pick? The correct answer is C. End of the next business day. C is correct because commission rules give a sales associate until the end of the next business day following receipt to deliver an escrow item to the broker or employer. Rule 61J2 14.009 Florida Administrative Code states that deadline. A is wrong because no rule demands that an associate hand the check over on the spot while still standing in the buyer's home. The associate needs a workable window to reach the office, and the rule supplies one measured in business days. B is wrong because the third business day is the broker's deadline rather than the associate's. Once the broker has the funds in hand, that longer period governs the actual deposit into the trust account. D is wrong because a full week has no footing anywhere in the escrow rules. Funds held that long invite a failure to escrow charge against the associate and against the broker who should have been supervising her. Florida escrow law isn't about good intentions. It's about business days. And it sets two separate clocks for two separate people. A sales associate has no authority to hold escrow funds and cannot open or maintain a trust account. Only a broker can do that. Since the associate is legally an extension of the employing broker, any money she touches in a transaction belongs in the broker's custody. The law simply governs how long that trip from buyer's hand to broker's desk may take. Business day is a defined term and it carries real weight. Saturdays, Sundays, and legal holidays are not counted. So a Friday afternoon deposit doesn't go stale over the weekend. It simply lands on the following Monday, or Tuesday if Monday is a holiday. Both clocks start at the exact same moment when the associate takes the money. The associate must deliver to the broker by the end of the next business day, while the broker's window to place those funds in the trust account is a full 3 business days from that same starting point. Escrow money is someone else's property held in trust, which is why the Commission treats mishandling it so seriously. Remember, intake deadlines govern money coming in. While dispute deadlines like the 15 and 30 business day conflicting demands, rules govern money already in contention. Don't let the two blur together. Question 3. A widow in Vero Beach is granted the right to use and occupy a waterfront home for the rest of her natural life, after which ownership passes automatically to her late husband's daughter. Which of the following interests does the widow hold in that property? Your options are a life estate, B, a leasehold estate, C, a fee simple determinable, D, a tenancy at sufferance. Before I reveal it, which one do you think is right? The correct answer is A, life estate. A is correct because a life estate gives its holder full use and possession measured by a person's lifetime, with the property passing to the named remainder man the moment that measuring life ends. The widow holds exactly that interest. B is wrong because a leasehold rests on a lease and hands possession back to a landlord at a fixed point. Nothing in these facts involves rent or a landlord, and the widow's right runs for as long as she lives. C is wrong because fee simple determinable is ownership that ends automatically if a stated condition occurs, such as land ceasing to be used as a public park. No triggering condition of that kind appears anywhere here. D is wrong because tenancy at sufferance describes an occupant who stays after a lease has ended and who has no right to remain. This widow's occupancy was granted deliberately by the owner and is entirely lawful. A life estate is a freehold interest in real property, and its duration is measured by a human life rather than by a calendar date. The holder of a life estate is a true owner, not a tenant. She holds title, collects rents, and may sell or mortgage her interest, but she can never convey more than she has, because that interest disappears the moment the measuring life ends. An ordinary life estate is measured by the holder's own life, while one pure autre vie is measured by someone else's. Whatever remains afterward either passes to a named remainder man or reverts back to the grantor. Picture a widow living in a waterfront home for the rest of her life, while her husband's daughter holds the remainder. The widow pays taxes and keeps up the property, and when she dies, title shifts automatically to the daughter with no probate at all. Florida's Ladybird deed frees the life tenant from needing the remainder man's signature to sell, all while avoiding probate and preserving homestead protections. Whenever a question says, for the rest of her natural life with someone taking over afterward, the measuring life is the clock. Question 4. A homeowner in Cape Coral sells her house, and the buyer wants to keep making payments on her existing loan rather than obtain new financing. The lender reviews the note, refuses, and demands the full unpaid balance. Which clause permits that demand? Your options are A. Defeasance Clause, B. Escalation Clause, C. Alienation Clause, D. Subordination Clause. What's your answer? Commit to one before I continue. The correct answer is C. Alienation Clause. C is correct because an alienation clause, often called a due on sale clause, lets the lender call the entire unpaid balance due when the borrower transfers the property without lender approval. That is precisely the clause operating here. R is wrong because a defeasance clause deals with the end of the debt rather than its acceleration. It obliges the lender to release the mortgage lien once the borrower has satisfied the note in full. B is wrong because escalation belongs to leases and to adjustable payment schedules, where a stated event raises the amount owed going forward. Demanding the entire remaining balance at once is a completely different lender remedy. D is wrong because subordination changes the ranking of liens, letting a later lender step ahead of an earlier one in priority. Lien position is not what the lender objected to when ownership of the house changed hands. 4 mortgage clauses crowd together in license law because they all sound like they're about ending a loan. Sorting them by trigger, not remedy, is what actually earns points on the exam. The alienation clause is triggered by a transfer of ownership. The acceleration clause is triggered by default. The defeasance clause governs what happens after the debt is fully paid, and the subordination clause has nothing to do with ending a loan at all. It rearranges lien priority. Think of a loan as 2 things bound together, credit extended to a specific borrower and a lien on the property. A transfer keeps the lien in place but hands payment responsibility to someone the lender never approved, which is why the clause exists. Courts once refused to enforce these clauses until Congress preempted the states with the Garn-Saint-Germain Act. It also carved out exceptions: transfers to a surviving spouse or child, transfers between spouses and divorce, and transfers into a living trust where the borrower remains the beneficiary. On the exam, watch for transfer words like sells, conveys, or deeds paired with a lender demanding the full balance. That's alienation. Shift the facts to missed payments and its acceleration instead, because 3 of these clauses can produce the same demand letter for very different reasons. Question 5. A sales associate in Kissimmee begins showing homes to a buyer who walked into the office that morning. No written notice of any kind has been signed, and the associate never raised the subject of representation at all. Which brokerage relationship does Florida law presume exists? Your options are A. Single agent for the buyer, B. No brokerage relationship, C. Implied dual agency, D. Transaction broker. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. Transaction broker. D is correct because Florida presumes that all licensees are operating as transaction brokers unless a single agent or no brokerage relationship has been established in writing with the customer. Section 475-278 Florida Statute states that presumption directly. A is wrong because single agency is the fiduciary relationship. and Florida requires it to be created through a written notice delivered before or at the time representation begins. Silence between the parties never produces it. B is wrong because no brokerage relationship also depends on a written notice delivered before any property is shown, because this buyer signed nothing at all. The statutory default steps in instead of that arrangement. C is wrong because Florida prohibits dual agency outright, whether disclosed or not, so no sequence of events can create it. The transaction broker role exists precisely so brokers can lawfully assist both sides of a deal. In the late 1990s, Florida rebuilt how brokers relate to buyers and sellers, replacing old common law agency with a new statutory system built around one key idea: what happens when nobody signs anything. Florida law recognizes exactly 3 relationships a licensee can have with the public: single agency, which is full fiduciary loyalty to one party; transaction brokerage, limited representation without fiduciary duty; and no brokerage relationship, where the licensee simply facilitates. Dual agency was abolished outright and cannot exist by accident. When silence falls, the statute assigns transaction brokerage by default, and with it come 7 duties: honesty and fair dealing, accounting for funds, skill and diligence, timely presentation of offers, disclosure of material facts, limited confidentiality, and any duties added in writing. Limited confidentiality is the hinge, protecting both sides without demanding undivided loyalty to either. Single agency and no brokerage relationship both require written notice delivered before showing property or signing an agreement. Transaction brokerage requires nothing at all, which is exactly why it's the default when nobody raises the subject. Watch for absence words: no notice signed, nothing disclosed, showings that started immediately. That customer isn't unrepresented and isn't owed undivided loyalty. Florida has already assigned a default, and it's transaction brokerage. Question 6. An appraiser valuing a 3-bedroom home in Winter Park studies recent closed sales of similar homes on nearby streets. Then adjusts each sale price up or down for differences in lot size, garage space, and overall condition. Which approach to value is she using? Your options are: A. Cost approach, B. Income capitalization approach, C. Sales comparison approach, D. Gross rent multiplier method. Which would you go with? Lock it in before the reveal. The correct answer is C. Sales comparison approach. C is correct because the sales comparison approach values property by analyzing recent sales of comparable properties and adjusting each comparable for its differences from the subject. It carries the most weight when appraising single-family homes. A is wrong because the cost approach begins with the value of the vacant land and adds what it would cost to build the improvements new. Less accrued depreciation. No construction estimate appears anywhere in these facts. B is wrong because income capitalization converts the earnings a property produces into an estimate of value. An owner-occupied 3-bedroom house in Winter Park generates no rental income for the appraiser to capitalize. D is wrong because the gross rent multiplier is a shortcut used with rental property, relating sale prices to monthly rents collected. This appraiser is adjusting comparable sale prices for physical differences instead of studying rents. Let's unpack the theory behind the sales comparison approach, a method that turns recent closed sales into today's value estimate for a subject property. An appraiser gathers truly comparable sales, prices out every difference between them and the subject, and applies those dollar adjustments to each comparable's sale price. The adjusted prices are then reconciled together, narrowing down to one defensible value. One rule resolves most errors: always adjust the comparable, never the subject, because the subject's price is the unknown you're solving for. If a comparable is superior, subtract. If it's inferior, add. Remembered as comparable, better, subtract. The elements of comparison follow a strict order. The first four are transactional: property rights conveyed, financing terms, conditions of sale, and market conditions. Only after those does the appraiser turn to physical elements like location and characteristics such as living area, age, and condition. Underneath it all sits the principle of substitution. A rational buyer won't pay more than the cost of an equally desirable substitute, which is why this approach dominates residential work but struggles for one-of-a-kind properties like courthouses or churches. Question 7. Two siblings inherit a Gainesville property together, and the sister wants to release whatever interest she may hold to her brother. She is unwilling to promise that she owns anything at all or to defend the title later. Which deed fits that intention? Your options are A. General warranty deed, B. Special warranty deed, C. Personal representative's deed, D. Quitclaim deed. Don't overthink it. Which one feels right? The correct answer is D. Quitclaim deed. D is correct because a quitclaim deed transfers only whatever interest the grantor happens to hold at that moment and carries no warranties of title whatsoever. It is a standard instrument for releasing a possible or uncertain claim. A is wrong because a general warranty deed makes the broadest promises available in Florida, defending the title against every claim arising at any point in its history. That is far more than the sister is willing to give. B is wrong because with a special warranty deed, the grantor still guarantees something, namely that nothing clouded the title during her own period of ownership. Any warranty at all exceeds what she has agreed to sign. C is wrong because a personal representative's deed is executed by someone administering an estate under authority granted by a court. The sister already owns her share outright and is conveying in her own name. A general warranty deed is a set of promises attached to a transfer. A quitclaim deed is that same transfer with the promises deliberately removed. That single contrast explains almost everything about when each one gets used. The general warranty deed defends title all the way back through history, even against defects created by strangers decades earlier. The special warranty deed narrows that promise to only the grantor's own period of ownership. The quitclaim deed makes no promise at all, conveying only whatever interest the grantor happens to hold. That honesty is exactly why quitclaims clear clouds on title instead of selling property. A misspelled name, an uncertain heir, or a former spouse's marital interest can each be extinguished by having that person sign away whatever claim they might have, without asking them to guarantee anything. Florida layers on its own formal requirements a competent grantor, a named grantee, consideration, words of conveyance, a legal description, and the grantor's signature. Florida also demands 2 subscribing witnesses, a rule most states dropped long ago, and recording protects the grantee from later claimants. That's why title underwriters flag a recent quitclaim in the chain of title. It isn't a defect in the deed, it's the quitclaim doing exactly what it was built to do. Question 8. A buyer signs a contract for a home in a Port St. Lucie subdivision where membership in the Homeowners Association is mandatory for every parcel owner. Florida requires that the buyer receive a disclosure summary and gives a limited right to cancel afterward. How long does that right last? Your options are A. 3 days after receiving the summary, B. 10 days after receiving the summary, C. 15 days after receiving the summary, D. 30 days after receiving the summary. Got a guess? Lock it in. The correct answer is A. 3 days after receiving the summary. A is correct because the Homeowners Association disclosure summary carries a right to void the contract within 3 days after the buyer receives it, or before closing, whichever comes first. Section 724(1 Florida Statutes creates that right. B is wrong because 10 days is the timeshare cancellation period, a separate right created under the Vacation and Timeshare Chapter. Mandatory association membership in a subdivision carries a much shorter cancellation window than that. C is wrong because 15 days belongs to a buyer purchasing a brand new unit directly from a condominium developer. That longer period was written for developer sales and does not reach subdivision association disclosures. D is wrong because 30 days appears nowhere in the association disclosure statute. Attaching a month-long escape to every subdivision contract would leave sellers waiting far longer than the legislature ever contemplated when it drafted this requirement. A signed contract can still unravel if a buyer discovers something the listing photos never showed. In Florida, mandatory homeowners association purchases come with a short window to walk away over exactly that kind of surprise. Chapter 7:20 attaches real obligations to the land itself. The summary must plainly state that membership is mandatory, that assessments can increase without a vote, that unpaid amounts can become a lien, and that covenants govern everyday details like paint, fences, rentals, and pets. The clock starts running the moment the buyer actually receives the summary, not when the contract was signed and not when it was mailed. That right also disappears the instant closing happens, whichever of the two comes first. Florida tests 3 separate rescission windows against each other because the numbers sound so similar. A homeowners association purchase gets 3 days, a non-developer condominium resale gets 7 business days, and a timeshare gets 10 calendar days that can never be waived. Anchor each window to the chapter that created it. Homeowners associations get the shortest window because the summary is brief. Condos need business days to review a full document package. And timeshares get the longest window to counter high-pressure sales. This right fixes a missing disclosure, not buyer's remorse. Question 9. An applicant in Tampa is preparing to sit for the Florida Sales Associate examination and wants to confirm that she meets the personal qualifications. Which requirements does the license law impose on a natural person applying for that license? Your options are A. Citizenship and Florida residency, B. A college degree and employer references, C. Age 18 and a high school diploma, D. Age 21 and good credit. Which one is it? Pause the video if you need more time. The correct answer is C. Age 18 and a high school diploma. C is correct because a natural person must be at least 18 years old, hold a high school diploma or its equivalent, and be honest, truthful, trustworthy, and of good character. Section 475D, Florida statutes, lists those qualifications. A is wrong because neither United States citizenship nor Florida residency is required to hold a Florida license. Non-residents are licensed under a separate section of the license law and simply carry additional notification duties. B is wrong because the statute sets its education floor at the high school level rather than requiring a college degree, and it examines an applicant's character and reputation instead of asking for references from past employers. D is wrong because the minimum age is 18 rather than 21. And nothing in the qualifications section imposes a credit standard. The law asks instead about honesty and a reputation for fair dealing. Florida's sales associate license requirements aren't one big list. They sort neatly into 3 separate buckets, and knowing which bucket a question is testing is the real skill. Personal qualifications describe who a person must be. Educational prerequisites describe what must be completed before the state exam. Post-licensure obligations describe what a new licensee must do afterward to keep the license alive. The actual list is short, at least 18, a high school diploma or equivalent, a social security number tied to child support enforcement, and a reputation for honesty and good character. What trips people up is what's missing. Florida residency, U.S. citizenship, and a college degree are not required. Florida licenses non-residents freely, and mutual recognition lets licensees from other states pass a shortened Florida law-only exam. A criminal record alone rarely disqualifies anyone. The Commission weighs the offense, the time passed, and rehabilitation. But concealment is treated as its own act of dishonesty, and it is what actually ends applications. Question 10. A closing agent in Sarasota is preparing the settlement figures for a residential sale and lists the state tax that the clerk will collect when the warranty deed is presented for recording. Which tax is she showing on that line of the statement? Your options are A. Non-recurring intangible tax, B. Documentary stamp tax on the note, C. Local business receipts tax, D. Documentary stamp tax on the deed. Take a second. Which answer would you pick? The correct answer is D. Documentary stamp tax on the deed. D is correct because Florida charges documentary stamp tax on the deed, measured against the total consideration and collected by the clerk when the instrument is recorded. Section 201.002 Florida statutes sets that tax on conveyances. A is wrong because the non-recurring intangible tax attaches to the obligation secured by a mortgage on Florida real property. It travels with the mortgage being recorded and a cash buyer never encounters it. B is wrong because stamp tax on a note is measured against the borrower's written promise to repay and is charged at a different rate. A cash buyer who signs no note still owes tax on the deed itself. C is wrong because no local receipts tax is triggered by recording a conveyance in Florida. Charges the clerk collects at recording come from state tax statutes, not from any local business licensing ordinance. Every Florida closing involves a small family of state taxes, and telling them apart comes down to one question: what exactly is being taxed? Documentary stamp tax on deeds taxes the conveyance itself based on the total consideration paid. Documentary stamp tax on notes taxes the written promise to repay based on the loan amount. And the intangible tax taxes the mortgage lien recorded against the property at 2 mils per dollar of debt. Consideration is not just cash. It includes any mortgage balance the buyer assumes, property traded in exchange, and even the debt relief in a family deed with no money changing hands, which is why a gift deed with an underlying mortgage still triggers tax. By custom, the seller pays deed stamps since they're conveying the property, while the buyer pays the note stamps and intangible tax since they're the one borrowing. But this is custom, not statute. Any purchase contract can shift these charges to whoever the parties agree upon. When a question mentions consideration, it means deed stamps. When it mentions the amount financed, it means note stamps. And when it mentions mills or a lien, it means the intangible tax. The rates are easy to mix up, but the base always tells you which tax is which. Question 11. A sales associate in Boca Raton places a social media advertisement for one of her listings. The post shows her own name, her mobile number, and several photographs of the home, and nothing else appears anywhere in it. Which advertising requirement has she failed to meet? Your options are A. Including the brokerage firm's licensed name, B. Listing the broker's personal telephone number, C. Stating the property's assessed value, D. Naming the multiple listing service. Before I reveal it, which one do you think is right? The correct answer is A. Including the brokerage firm's licensed name. A is correct because every real estate advertisement must include the licensed name of the brokerage firm, placed adjacent to or immediately above or below the point of contact information. Rule 61J2 10.025, Florida Administrative Code requires it. B is wrong because the rule reaches the firm's license name rather than a personal telephone number for the broker. Publishing a brokerage phone line satisfies nothing if the firm itself is never identified in the advertisement. C is wrong because assessed value is a property tax figure and has never been an advertising disclosure requirement in Florida. Leaving it out of a listing post breaks no rule the Commission has adopted. D is wrong because participation in a multiple listing service is a private membership matter governed by that service's own rules. State advertising regulation aims at telling the public which brokerage stands behind the ad. Every real estate ad answers one question for the public: who is legally responsible for this listing? Hiding that answer creates what Florida calls a blind advertisement, and it's flatly prohibited. The rule is narrower than most licensees think. Whenever an ad gives a phone number, address, email, or website, the brokerage name must sit right next to it, not buried 3 screens away. The rule reaches every medium without exception. Print, signs, websites, texts, and social media all count as advertising the moment they promote a property or a service, and personal posts naming a listing are no exception. The brokerage, not the associate, is legally the advertiser, and the broker carries a supervisory duty over everything published. A post showing a name and mobile number, but no brokerage name, exposes both the associate and her broker to discipline. 3 violations get confused but are genuinely different. A blind ad omits the brokerage name, even if truthful. False advertising makes untrue claims like inflated square footage. And unauthorized advertising promotes a listing without the owner's consent. Reading for what's omitted, asserted, or promoted sorts them cleanly. Question 12. A surveyor describes an irregular parcel along a river in Alachua County by starting at an iron pipe, then running a series of compass directions and distances that eventually close back at that same pipe. Which method of legal description is being used? Your options are A. Lot and block, B. Government survey, C. Air lot description, D. Meets and bounds. What's your answer? Commit to one before I continue. The correct answer is D. Meets and bounds. D is correct because meets and bounds describes land by directions and distances running from a point of beginning, following the boundary until it returns to that same point. Irregular parcels are almost always described this way. A is wrong because lot and block identifies a parcel by referring to a recorded subdivision plat rather than by tracing its perimeter on the ground. That shortcut requires a plat already on file with the county. B is wrong because the government survey system locates land within townships, ranges, and sections laid out on a rectangular grid. Its descriptions name positions on that grid instead of following a winding riverfront boundary. C is wrong because an air lot describes the space above a parcel, which matters for condominium units and other vertical divisions of ownership. Ground level boundary lines are not what such a description resolves. Before grids and plats existed, surveyors described land by walking its edges. That method, called meets and bounds, is still alive in Florida deeds today. Meets refers to the measured distances, while bounds refers to the directions and the boundaries themselves. Every description starts at a point of beginning and moves thence, course by course, until it closes. Picture the surveyor's path. An iron pipe marks the point of beginning. Each course records a bearing and a distance, and the final course must return exactly to that starting pipe. If it doesn't close, the description fails to enclose any area at all. When elements conflict, courts follow a clear priority order. Natural monuments like a river or a great tree outrank everything. Artificial monuments like an iron pipe or fence come next, and recorded courses and distances yield to both. Whenever you see a point of beginning, the word thence, bearings and distances, and a closing return to that starting monument, you're looking at a meets and bounds description, not an address or a tax number. Question 13. A borrower in Jacksonville signs a note and a mortgage on her home. Her cousin in another state described the lender as owning legal title until the debt is repaid. Which statement correctly describes Florida law for her mortgage? Your options are: A. The lender holds only a specific lien. B. The lender holds legal title until payoff. C. The lender and borrower share title. D. A trustee holds title for the lender. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. The lender holds only a specific lien. A is correct because Florida is a lien theory state, so a mortgage is a specific lien against the described property rather than a conveyance of legal title or of the right of possession. Section 69702 Florida Statutes. B is wrong because that description fits title theory jurisdictions, where the lender genuinely does hold title until the debt is satisfied. Florida rejected that arrangement by statute and left full ownership with the borrower. C is wrong because shared ownership between borrower and lender is not how mortgage security works in any state. The lender's interest is a claim enforceable against the property, not a slice of the ownership itself. D is wrong because a trustee holding title describes deed of trust states, which use a three-party arrangement to permit sale without a lawsuit. Florida mortgages are two-party instruments foreclosed through the courts. Every mortgage exam question rests on one question. What does a mortgage actually give the lender? Two competing legal theories answer that differently, and Florida picks one of them decisively. Under title theory, the borrower conveys legal title to the lender and only gets it back after repayment. Under lien theory, the borrower keeps legal title the whole time, and the lender receives nothing but an enforceable lien. Florida's statute says a mortgage is a specific lien, not a conveyance of title or possession. The mechanism behind this is hypothecation, pledging property as security while keeping possession and use of it. A Jacksonville borrower who signs a mortgage keeps living in her home, renting it, improving it, even selling it, because the lender is a creditor holding collateral, not an owner waiting out a repayment period. Two documents do two jobs. The promissory note is the debt itself, and the mortgage is the security instrument that creates the lien. Because Florida's lender holds no title or possession, it can't simply take the property on default. It must file suit and win a judicial foreclosure through the courts. Liens also sort along two axes, specific versus general and voluntary versus involuntary. A mortgage is specific and voluntary. A judgment lien is general and involuntary. Tax and construction liens are specific and involuntary. Remember, in Florida, the bank never owns the house. It only holds the lien. Question 14. A buyer purchasing a beachfront unit in Fort Lauderdale asks what she will actually own once the sale closes. Her contract refers to a declaration recorded for the building and to shared hallways, elevators, and a pool deck. Which of the following describes her ownership? Your options are: A. Shares of stock in a lease. B. A long-term leasehold in the unit. C. The unit plus common element share. D. A percentage of the entire building. Which would you go with? Lock it in before the reveal. The correct answer is C. The unit plus common element share. C is correct because condominium ownership consists of fee title to the individual unit, together with an undivided interest in the common elements that all owners share. The recorded declaration is what creates that arrangement. A is wrong because stock paired with a proprietary lease describes cooperative ownership, where a corporation owns the building and each resident holds shares in it. A declaration of condominium creates a very different structure. B is wrong because a long leasehold gives possession for a term of years without ownership of the unit. This buyer takes title to her unit, which she is free to sell, mortgage, and leave to her heirs. D is wrong because owning a percentage of the whole building with no exclusive claim to any unit would leave the buyer unable to sell her home separately. Each condominium unit is separately owned and separately conveyed. Buying a condo means acquiring two things at once, and the second one never shows up in the listing photos. She takes fee simple title to her individually defined unit, plus an undivided share of the common elements held with every other owner. Recording the declaration of condominium is what creates the split, defining boundaries, percentages, assessments, and voting all at once. Common elements are everything that isn't a unit: the land, roof, hallways, elevators, and pool. Limited common elements, like an assigned parking space or a private balcony, stay common property but are reserved for one unit's exclusive use. Owners hold the common elements collectively as tenants in common. The association is just their agent, managing and enforcing rules without ever owning the roof or the pool. The declaration's percentage share then drives assessments, voting weight, and any payout if the condominium is ever terminated. That shared structure is exactly why aging coastal buildings now face milestone inspections and reserve studies. Condominium ownership sits between a cooperative's stock and lease model and an HOA's separately owned lots, your own space, and a stake in everything around it. Question 15. A buyer contracts to purchase a condominium unit in Clearwater from the current owner rather than from a developer, and receives the required documents at signing. She calls her licensee the next morning. How long does she have to cancel that contract? Your options are A. 3 calendar days after execution, B. 7 days excluding weekends and holidays, C. 15 days after execution, D. There is no cancellation right on resales. Don't overthink it. Which one feels right? The correct answer is B. 7 days excluding weekends and holidays. B is correct because a non-developer condominium resale is voidable within 7 days, excluding Saturdays, Sundays, and legal holidays, after execution and receipt of the required documents. Section 78503 Florida Statutes was amended to that period in 2025. A is wrong because 3 calendar days was the resale window under earlier law, and the 2025 amendment replaced it. Older study material still repeating that shorter figure is now out of date and will mislead candidates. C is wrong because 15 days applies when a developer sells a new unit and must deliver the complete developer disclosure package. A sale by an existing owner runs on the shorter resale clock instead. D is wrong because the cancellation right does survive on resales, although it is narrower than the developer version. Both the period and the document delivery requirements sit in the Condominium Chapter and cannot be ignored. Florida gives every condominium buyer a right to cancel, but how long that right lasts depends entirely on who is selling. A purchase from the developer allows 15 days from contract signing or document delivery, whichever comes later. A resale from an existing owner allows only 7 business days, excluding weekends and holidays. Same statute, same property, but the seller's identity flips the switch. The resale clock does not start when the contract is signed. It starts only once the seller delivers the full document package, the declaration, articles of incorporation, bylaws, rules and regulations, an FAQ sheet, a governance form, and the association's most recent year-end financials. Because the resale window excludes Saturdays, Sundays, and legal holidays, the true deadline lands later than a calendar count suggests, sometimes nearly a week and a half out. Reading those financials matters too, since they reveal underfunded reserves, pending assessments, and looming structural inspection costs after Surfside. The right to cancel is absolute but strict. Written notice is required, it can't be waived, and it disappears the moment you close. Whenever a question names the seller as the current owner, it's pointing you straight to the 7 business day resale rule. Question 16. A broker in Melbourne is operating as a transaction broker. The seller asks him to keep quiet about a competing offer and to place the seller's interest above the buyer's throughout the negotiation. Which duty does a transaction broker not owe to a party? Your options are A. Accounting for all funds. B. Skill, care, and diligence. C. Loyalty to one party. D. Limited confidentiality. Got a guess? Lock it in. The correct answer is C. Loyalty to one party. C is correct because loyalty belongs to the single agent relationship rather than the transaction broker relationship. A transaction broker provides limited representation to both sides and owes 7 duties that stop well short of undivided loyalty. Is wrong because accounting for all funds appears on every duty list Florida recognizes, including the transaction brokers. Handling other people's money correctly is required no matter which brokerage relationship the licensee chose. B is wrong because using skill, care, and diligence in the transaction is expressly among the 7 transaction broker duties. No licensee can trade competence away by declining to serve as a fiduciary. D is wrong because limited confidentiality is one of the 7 listed transaction broker duties, and a party may waive it only in writing. The duty is owed to the customer, so it belongs on the list. Florida law gives a single agent 9 duties and a transaction broker 7. The gap between those 2 lists is where most exam questions hide. 4 items change when you move from single agent to transaction broker. Loyalty vanishes, obedience vanishes, full disclosure vanishes, and full confidentiality shrinks to limited confidentiality. Those are exactly the duties that make representation feel like advocacy. Limited confidentiality protects only a short list, that the seller will take less than asking price, that the buyer will pay more than offered, either party's motivation, and anything specifically marked confidential. Everything else can be shared, and none of it requires the broker to fight for either side. When a seller asks her transaction broker to hide a competing offer and put her interests first, only half that request is legal. Withholding the offer is fine, but placing her interests first is loyalty, and loyalty isn't on the transaction broker's list. So agreeing to it misrepresents the relationship. When a question asks which duty a transaction broker does not owe, think loyalty first. When it asks which duty survives every relationship, think honest dealing, accounting for funds, and disclosure of material defects. Question 17. An appraiser estimating the value of a 40-year-old office building in Pensacola subtracts amounts reflecting the worn roof, the outdated single-pane windows, and the noisy highway that was recently widened beside the property. What is she measuring with those 3 deductions? Your options are A. Depreciation, B. Amortization, C. Assemblage, D. Capitalization. Which one is it? Pause the video if you need more time. The correct answer is A. Depreciation. A is correct because depreciation is loss in value from any cause, and it covers physical deterioration, functional obsolescence, and external influences originating beyond the property line. All 3 of those forms appear in her deductions. B is wrong because amortization describes the gradual repayment of a debt through scheduled installments over time. It tracks a shrinking loan balance, and a building's condition never enters that calculation at all. C is wrong because assemblage refers to combining adjoining parcels under a single owner, usually to create added value. This appraiser is reducing her value estimate, and no neighboring parcels are being joined together. D is wrong because capitalization converts an income stream into an indication of value for an investor. That process answers what a building earns, not how much its age and its surroundings have cost it. That old office building in Pensacola is losing value for several different reasons at once. Appraisal depreciation simply means loss in value from any cause, measured against the cost to build new today. It's not a schedule or a tax formula. It's the gap between cost new and what the improvements actually contribute in today's market. Every deduction the appraiser lists falls into one of three categories. Physical deterioration is wear and tear on the structure, like that aging roof. Functional obsolescence is a design problem inside the property, like single-pane windows or a chopped-up floor plan. External obsolescence comes from entirely outside the property lines, like that closed employer down the street. The key test is location. Physical and functional problems live inside the property boundary and can sometimes be cured by spending money on the building. External obsolescence originates entirely outside that boundary, which is why it's always treated as incurable. No owner can fix a closed employer or a declining neighborhood by renovating. Two vocabulary traps matter here. Effective age reflects condition and updates, not the year on the cornerstone, and it drives the age-life method. And appraisal depreciation is nothing like tax depreciation, which recovers cost on a fixed 27 or 39-year schedule no matter what's happening to market value. Depreciation only shows up explicitly in the cost approach, and land is never depreciated because it doesn't wear out or go obsolete. Keep physical, functional, and external straight, and you'll avoid the most common category of appraisal errors. Question 18. A buyer in Ocala obtains a final court judgment against a sales associate for damages arising out of a brokerage transaction, and she cannot collect $1 of it. How much can the real estate recovery fund pay her? Your options are A. The full judgment regardless of amount. B. An amount the commission sets annually. C. Twice the amount of her lost deposit. D. The unpaid judgment or $50,000. Take a second. Which answer would you pick? The correct answer is D. The unpaid judgment or $50,000. D is correct because the fund pays the unsatisfied portion of the judgment or $50,000, whichever is less, and all claims arising from a single transaction share that same aggregate ceiling. Section 475-484 Florida Statutes. A is wrong because paying judgments without any limit would quickly drain a fund supported by modest licensee fees. The statute caps each individual claim and separately caps total payments made against any one licensee. B is wrong because the Commission does not reset that ceiling from year to year. The figure sits in the statute itself, so changing it would take an act of the legislature rather than a rule amendment. C is wrong because no doubling provision exists anywhere in the recovery fund statutes. The fund reimburses actual damages a court has already determined and left unpaid, subject to its stated dollar ceiling. Before this fund existed, a defrauded consumer could win a judgment against a licensee and still collect nothing because the licensee had no assets and no insurance. Discipline against the licensee restores nothing to the victim. The legislature built the fund to close exactly that gap. The fund is a pool financed by a slice of licensee fees, not general tax revenue, and it exists to reimburse people holding uncollectible judgments against Florida licensees. It covers compensatory damages only. Punitive damages, interest, attorney fees, and court costs are excluded. The fund pays the unsatisfied judgment or $50,000, whichever is less per transaction, and that ceiling is shared even if several claimants were harmed in the same deal. Against any single licensee, total exposure across all transactions is capped at a higher aggregate figure. Qualifying is demanding. She needs a final judgment against a licensed person for a violation like fraud or trust fund conversion, a writ of execution returned unsatisfied, a reasonable search showing no assets, and a timely filing within the statutory period. Skip any step and she recovers nothing. When the fund pays, the licensee's license is automatically suspended without a hearing until full repayment plus interest, because the payment is an advance, not a forgiven debt. Remember, the fund sits last in line. After insurance and escrow disputes, only once a judgment has already proven worthless. Question 19. A homeowner in Bradenton holds a recorded right to cross her neighbor's driveway to reach a public street, and that right passes automatically to whoever buys her property later. Which term describes her own parcel in this arrangement? Your options are A. The servient tenement, B. The dominant tenement, C. An easement in gross, D. A revocable license. Before I reveal it, which one do you think is right? The correct answer is B. The dominant tenement. B is correct because the parcel that benefits from an appurtenant easement is the dominant tenement, and the benefit runs with that land to every future owner. The burdened neighboring parcel is the servient tenement. A is wrong because the servient tenement is the parcel carrying the burden, which here is the neighbor's driveway. Calling the benefited property servient reverses the two labels the doctrine depends on. C is wrong because an easement in gross benefits a person or a company rather than a parcel of land. As with a utility line, this right attaches to the property and transfers automatically with the sale. D is wrong because a license is personal permission that an owner may revoke at will and that does not survive a sale of either property. A recorded right passing to future buyers is far more durable. An easement is a non-possessory right to use someone else's land for a specific purpose. The holder gains a right of use but never ownership or exclusive occupancy. When a right benefits a particular parcel rather than a person, it's called an easement appurtenant. The dominant tenement receives the benefit. The servient tenement carries the burden, and both pass automatically to future owners regardless of what the deed says. Picture a homeowner whose lot has no direct road access, crossing her neighbor's driveway to reach the public street. Her lot is the dominant tenement, benefiting from the crossing, while the neighbor's lot is the servient tenement, burdened but still fully owned. An easement in gross is different. It benefits a person or company, not a parcel, so there's no dominant tenement at all. Think of a power company's lines crossing 100 properties. Commercial easements in gross transfer with the business, while personal ones end with the individual. Three imposters crowd this concept. A license is mere revocable permission. An encroachment is an unauthorized intrusion with no right at all. And a restrictive covenant limits what an owner does with her own land. Only a recorded right to cross that runs with the land is a true easement appurtenant. Question 20. A mortgage banker in Orlando closes residential loans using her own funds and then sells those closed loans to a national agency that pools them and issues securities to investors. Which market has she entered when she makes those sales? Your options are A. The primary mortgage market, B. The commercial paper market, C. The secondary mortgage market, D. The interbank lending market. What's your answer? Commit to one before I continue. The correct answer is C. The secondary mortgage market. C is correct because the secondary mortgage market is where existing loans are bought, sold, and pooled, which restores the lender's funds so that more borrowers can be served. Selling closed loans to an agency happens there. A is wrong because the primary market is where a lender and a borrower meet and the loan is originated. That step was already finished when this banker funded the loan at the closing table. B is wrong because commercial paper refers to short-term unsecured borrowing by corporations to cover immediate operating needs. Mortgage loans secured by real property move through entirely different channels and reach different investors. D is wrong because interbank lending covers banks lending reserve balances to one another, frequently overnight and in very large amounts. None of that activity involves the sale or purchase of individual residential mortgage loans. Before 1930, a local bank could only lend out what its depositors had saved, and once that money was tied up in long mortgages, lending simply stopped. Money also piled up where wealth already existed, leaving growing regions starved for loans while the Depression froze what little credit remained. The fix was structural, split lending into two markets. In the primary market, a lender closes a loan with her own funds. In the secondary market, that closed loan is sold, pooled, and turned into securities, sending fresh cash back so the same money can fund borrowers again and again. Picture a mortgage banker in Orlando closing a loan with her own funds. She sells that loan to a national agency, which pools it with thousands of others and issues securities that investors worldwide buy for the income stream, and that purchase money flows right back to her so she can lend again. 3 agencies dominate the system. Fannie Mae was chartered in 1938 to revive a dead market. Ginnie Mae was split off in 1968 to guarantee government and veteran-backed securities. And Freddie Mac arrived in 1970 to serve savings institutions and compete with Fannie Mae, because loans must meet their standards to be sold. Those standards became the industry's conforming guidelines. Remember that selling a loan and servicing it are separate deals, which is why payment addresses can change while loan terms stay identical. And the real dividing line is simple. A mortgage banker funds the loan and can cross into the secondary market by selling it, while a broker never funds anything at all. Question 21. A broker in Tallahassee receives an escrow deposit from her sales associate on a Thursday afternoon, and she wants to place it correctly. The license law simply uses the word immediately. How quickly must that money reach the trust account? Your options are A. End of the 3rd business day, B. By the end of the same day, C. Within 10 calendar days, D. Before the seller accepts the offer. Pick one, trust your gut. Here's your chance to test yourself. The correct answer is A. End of the 3rd business day. A is correct because the Commission reads the word immediately to mean no later than the end of the 3rd business day following receipt, and Saturdays, Sundays, and legal holidays are not counted. Rule 60 AJ2 14 or reads Florida Administrative Code. B is wrong because depositing funds the same day is excellent practice but is not the standard the rule actually sets. The Commission defined that statutory word in business days precisely to avoid such a reading. C is wrong because 10 calendar days sits far outside every escrow deadline Florida imposes, and a broker who holds client funds that long risks a failure to escrow charge under the license law. D is wrong because acceptance by the seller has no bearing on the deposit clock at all. The obligation to place funds in escrow begins on receipt, whether or not a binding contract ever comes together. Florida's escrow statute says a broker must deposit trust funds immediately, but immediately is a term of art, not a plain English word. The Florida Real Estate Commission defines it by rule, and that rule, not the dictionary, controls. Business days exclude weekends and holidays, so a Thursday receipt does not expire on Sunday. The clock starts the moment the sales associate takes the money, not when it reaches the broker. So a broker who assumes delivery restarts the count can be late without ever realizing it. The account itself is tightly regulated. It must sit in a Florida institution, stay separate from the operating account, and be titled to show its trust character. Interest is only allowed with written consent from all parties, and commingling trust money with brokerage money is a violation on its own, even if nothing is ever lost. Every month the broker must reconcile the account in writing, comparing total trust liability against the actual bank balance, explaining any gap, and signing and dating the statement. When the numbers disagree with no explanation, an auditor sees either sloppy bookkeeping or a shortage, and the law treats both seriously. Immediately, business day and reasonable time all carry fixed meanings under license law that override ordinary usage. Knowing that distinction is exactly what these exam questions are testing. Question 22. A borrower in Lakeland misses 4 consecutive monthly payments on her mortgage. The lender notifies her that the entire remaining balance of the loan is now due at once, rather than in the scheduled monthly installments. Which clause permits the lender to make that demand? Your options are A. Alienation Clause, B. Acceleration Clause, C. Defeasance Clause, D. Habendum Clause. Which would you go with? Lock it in before the reveal. The correct answer is B. Acceleration Clause. B is correct because an acceleration clause allows the lender to declare the whole unpaid balance immediately due when the borrower defaults. Invoking it is the step that must come before a foreclosure suit can be filed. A is wrong because an alienation clause is triggered by a transfer of the property rather than by missed payments. This borrower still owns her home in Lakeland and has sold nothing to anyone. C is wrong because a defeasance clause obliges the lender to release the mortgage once the debt has been fully satisfied. It operates at the successful conclusion of a loan rather than at the point of collapse. D is wrong because the Habendum clause belongs to deeds, where it defines the extent of the estate the grantor is conveying. Loan documents contain no such clause and could not use one to demand payment. Imagine a lender forced to sue for one missed payment at a time for 30 years straight. No lender would ever agree to that, so mortgages include a fix, the acceleration clause. The clause lets the lender declare the entire unpaid balance due immediately, but only once a real default occurs. Default can mean missed payments, unpaid taxes, lapsed insurance, or breaking any other promise in the mortgage. The Florida sequence runs in a fixed order: default, a notice of default with a cure period, then acceleration of the full balance, and only after that a foreclosure complaint and lies pendants, followed by judgment, sale, and the certificates that finalize title. Before acceleration, the borrower can simply reinstate by paying the missed installments. After acceleration, that right disappears, replaced by equitable redemption, which demands the whole accelerated balance. And that right vanishes once the certificate of sale is filed, with no redemption period after. Acceleration is permissive, a deliberate choice the lender makes, and it always comes before foreclosure, never after. Spot it by the conduct that caused it. Broken promises mean acceleration, while a transfer of ownership points instead to the alienation clause. Question 23. An investor pays a landowner in Ocala a sum of money for the exclusive right to buy a parcel at a fixed price within the next 6 months. The landowner may not sell to anyone else during that period. Which contract has the parties created? Your options are A. An option contract, B. A right of first refusal, C. An installment sale contract, D. A net listing agreement. Don't overthink it. Which one feels right? The correct answer is A. An option contract. A is correct because an option gives its holder the exclusive right to purchase on agreed terms for a stated period, binds the seller for that period, and leaves the option holder free to walk away. B is wrong because a right of first refusal only lets its holder match an offer the owner has decided to accept from someone else. This investor can force a sale on his own initiative at a price already fixed. C is wrong because under an installment contract, the buyer takes possession and pays over time while the seller retains title until the balance is paid. Here, nobody has actually agreed to buy the parcel yet. D is wrong because a net listing concerns how a broker is compensated out of the proceeds of a sale. The arrangement described involves no brokerage compensation and instead creates a purchase right for an investor. Most real estate contracts bind both sides the moment they're signed. An option is different, and that asymmetry is the whole concept worth understanding. The optional sells the exclusive right to buy on fixed terms and is stuck with that promise. The optionee owes no promise back. She can walk away owing nothing, because her money bought the privilege of deciding later, not the property itself. The option money pays for the option itself, not for the eventual purchase. It's generally non-refundable because the optioner already delivered what was bought, a period when the property stayed off the market. Whether it credits toward the purchase price depends entirely on the agreement's wording. Before exercise, no purchase contract exists and neither party must close. The moment the optionee properly exercises, following the required written notice within the deadline, the option ripens into a full bilateral contract, and every remedy of an ordinary sale, including specific performance, becomes available to both sides. Timing is a wall, not a target. Exercise a day late and the option is simply dead. This is what separates an option from a right of first refusal. The option holder can compel a sale at a price already fixed whenever she chooses, while a right of first refusal only lets her match whatever offer the owner independently decides to accept. Question 24. A married couple in Coral Gables take title to their home in a form that gives each spouse an undivided whole interest, shields the property from the separate creditors of either spouse, and passes ownership automatically to the survivor. Which form of ownership is that? Your options are A. Tenancy in common, B. Joint tenancy without survivorship, C. Community property, D. Tenancy by the Entireties. Got a guess? Lock it in. The correct answer is D. Tenancy by the Entireties. D is correct because tenancy by the Entireties is available only to married couples, treats the spouses as a single owning unit, carries the right of survivorship, and shields the property from creditors of one spouse alone. Is wrong because tenancy in common carries no survivorship at all, so a deceased owner's share passes under her will or to her heirs. It also offers no shelter from the creditors of an individual owner. B is wrong because stripping survivorship out of a joint tenancy leaves an ownership form that behaves much like a tenancy in common. Automatic passage of the whole property to the surviving spouse would then be impossible. C is wrong because community property is the marital ownership system used in a handful of western states. Florida never adopted it, so no deed recorded in Coral Gables can create that particular estate. In Florida, married couples can hold property as tenants by the Entireties, a form of ownership that treats the spouses not as two half owners, but as a single legal unit. Creation rests on 5 unities. 4 are ordinary: time, title, interest, and possession. The 5th unity of Pearson is the marriage itself, and it's what limits this form to married couples alone. Each spouse owns the undivided whole, not a half interest apiece, because the law treats them as one unit. A creditor of only one spouse has nothing separate to attach. The home stays out of reach. Compare the 3 forms. Tenancy in common allows unequal shares with no survivorship. Joint tenancy gives survivorship, but any owner can sever it, and it offers no creditor protection. Entireties requires marriage, can't be severed by one spouse, and shields the property from that spouse's creditors. Divorce destroys the unity of Pearson, turning entireties into a plain tenancy in common. Florida presumes entireties for married couples on any deed unless stated otherwise, and extends it to bank accounts too. But the shield isn't absolute, since joint debts and federal tax liens can still reach it. Question 25. A licensee reviewing a rural listing in Marion County finds the parcel identified by township, range, and section numbers rather than by a plat reference. Her buyer asks how the sections inside a township are numbered. Which description is accurate? Your options are A. From the southwest corner running east, B. Clockwise beginning at the center, C. From the northeast corner alternating direction, D. In 4 quadrants of 9 sections. Which one is it? Pause the video if you need more time. The correct answer is C. From the northeast corner alternating direction. C is correct because section 1 sits in the northeast corner of a township. Numbering runs west across the top row, drops to the next row, reverses direction, and snakes back and forth until it reaches section 36. A is wrong because beginning in the southwest corner reverses the actual pattern used on the survey grid. That corner holds section 31, which starts the final row rather than the first one. B is wrong because no spiral or clockwise numbering appears in the rectangular survey system. Sections are counted in straight rows that alternate direction, which keeps consecutively numbered sections next to one another. D is wrong because townships are not divided into quadrants for numbering purposes at all. Quarters describe divisions inside a single section, and every township holds 36 sections arranged in 6 rows. Florida's rectangular survey system starts with 2 reference lines crossing at a single initial point, a principal meridian running north-south, and a baseline running east-west. Florida uses the Tallahassee principal meridian and its baseline, so every township and range measurement in the state starts there. Township lines create tiers north and south of the baseline, and range lines create columns east and west of the meridian. Where they cross sits a township, a 6-mile square split into 36 sections, and each section holds 640 acres, the number behind nearly every acreage calculation. The numbering pattern is called boustrophodonic, after the path of an ox ploughing a field. Section 1 sits in the northeast corner. Numbering runs west to section 6 in the northwest, drops a tier, reverses, and snakes back and forth until section 36 lands in the southeast. Because of that snaking pattern, the true diagonal opposites are section 1 and section 31, and section 6 and section 36. A reliable check relies on sums, not differences. Stacked sections in the top 2 tiers add to 13. The next pair of tiers adds to 25, and each successive pair adds 12 more. Legal descriptions are read from the end backward, and multiplying the denominators of each fraction lets you divide 640 acres directly to find the parcel size. Correction lines, guide meridians, and government lots fix the curvature of the earth along the way. Ultimately, township and range language tells a licensee the land sits outside any platted subdivision. Question 26. A licensee in Fort Myers plans to work with a buyer who wants no representation whatsoever, and the buyer signs the appropriate notice before any property is shown. Which obligations does the licensee still owe to that buyer? Your options are A. Honesty, material disclosure, and accounting. B. Loyalty, obedience, and confidentiality. C. Only presenting offers promptly. D. No duties at all after signing. Take a second. Which answer would you pick? The correct answer is A. Honesty, material disclosure, and accounting. A is correct because in a no brokerage relationship, the licensee still owes 3 duties: dealing honestly and fairly, disclosing known facts that materially affect residential value and are not readily observable, and accounting for entrusted funds. Section 475-2278 Florida Statutes. B is wrong because loyalty, obedience, and confidentiality are fiduciary obligations reserved for the single agent relationship. Declining representation altogether is exactly what removes those 3 duties from the list of obligations owed to this buyer. C is wrong because presenting offers in a timely manner appears on the transaction broker and single agent duty lists, rather than this one. The duties that survive here are broader than that single task. D is wrong because signing the notice narrows the relationship, but never erases every obligation the licensee carries. Honesty, disclosure of hidden material defects, and proper handling of money continue in every case. Florida allows a licensee to represent nobody at all, but even at that floor, 3 duties never disappear. No brokerage relationship strips away representation, yet honesty, disclosure, and accounting for money remain. This relationship exists because some consumers genuinely don't want representation. So Florida lets a licensee handle paperwork without owing fiduciary duties, as long as a written no brokerage relationship notice is delivered before showing property. Otherwise, transaction brokerage forms by default. This disclosure duty traces back to Johnson versus Davis in 1985, where Florida's Supreme Court rejected the old buyer beware rule for residential sales and required sellers to disclose known, material, hidden defects. Florida then wrote that same obligation into every licensee's duties, no matter who they represent. 3 duties survive at every level: dealing honestly and fairly, disclosing known material residential defects that aren't readily observable, and accounting for all entrusted funds. A cracked driveway in plain sight fails that disclosure test, but hidden sinkhole activity does not. Florida's 3 relationships form a ladder: 9 duties in single agency, 7 in transaction brokerage, just 3 with no relationship, but honesty, material disclosure, and accounting for funds are conditions of holding a license, and they never go away. Question 27. A closing agent in Tampa is preparing the settlement statement for a residential sale. The buyer paid a good faith deposit several weeks earlier, and the listing broker has been holding that money in escrow ever since. How is the deposit shown at closing? Your options are A debit to the seller, B, a credit to the buyer, C, a credit to the seller, D, a debit to the listing broker. Before I reveal it, which one do you think is right? The correct answer is B, a credit to the buyer. B is correct because earnest money already paid reduces what the buyer must bring to the closing table, so it appears as a credit to the buyer on the settlement statement. The seller's side of the statement is unaffected. A is wrong because charging the seller for the buyer's own deposit would effectively make the seller pay it twice. The seller is credited with the full purchase price, and the deposit simply counts toward that amount. C is wrong because crediting the seller would hand him money the buyer has already advanced toward the price. That entry belongs squarely on the buyer's side of the settlement statement instead. D is wrong because the broker holds these funds as escrow agent rather than as a party to the sale. Settlement entries record what the buyer and the seller owe, not what the escrow holder has been keeping. Every line on a settlement statement is either a debit, a charge someone owes, or a credit, an amount someone has already provided or is entitled to. The buyer's column and seller's column are totaled separately, ending in one number each, cash the buyer must bring, and proceeds the seller walks away with. Most entries appear twice, once on each side, because money moves between parties. The purchase price is a debit to the buyer and a credit to the seller. Prepaid rent works the same way, debited to the seller and credited to the buyer. But earnest money only appears once as a credit to the buyer, because the seller was already credited the full price and the deposit is just part of it paid early. Earnest money never goes to the seller directly. It sits in a trust account held by the broker, title company, or closing agent as the buyer's money, subject to the contract. At closing, it's released and applied against what the buyer owes, while the seller's proceeds never change. 2 other single-sided entries follow the same logic. New loan proceeds are a credit to the buyer only, reducing what the buyer brings. payoff of the seller's existing mortgage is a debit to the seller only, since that debt belongs to the seller alone. Grouping these together removes most of the guesswork. The trap is assuming that because the seller eventually benefits from the deposit, it must appear on the seller's side too. It doesn't, because the seller was already credited the full purchase price. Record the deposit where it belongs as a credit to the buyer and nowhere else. Question 28. An appraiser valuing a small apartment building in St. Petersburg gathers the annual rents, subtracts vacancy losses and operating expenses, and then applies a rate drawn from recent sales of similar buildings. Which approach to value is she applying? Your options are A. Sales comparison approach, B. Cost approach, C. Comparative market analysis, D. Income capitalization approach. What's your answer? Commit to one before I continue. The correct answer is D. Income capitalization approach. D is correct because income capitalization converts net operating income into a value estimate by applying a capitalization rate extracted from the market. Investors buy income property for its earnings, so this approach carries the greatest weight. A is wrong because sales comparison would rest on adjusted prices of comparable sales rather than on a rent roll and an expense statement. This appraiser is building value out of what the building earns each year. B is wrong because the cost approach measures what rebuilding the improvements would cost today, less depreciation, then adds land value. Vacancy allowances and operating expenses play no part in that particular calculation. C is wrong because a comparative market analysis is a pricing tool licensees prepare for sellers, and it is not one of the three recognized appraisal approaches. Its purpose is guiding a listing decision. An investor buying an apartment building isn't buying bricks and walls. She's buying the stream of income that building produces, and the structure is just the machine that delivers it. The arithmetic reduces to one relationship: income equals rate times value. Rearranged, value equals net operating income divided by the capitalization rate, and rate equals income divided by value. Since two of the three are always known, the same formula answers questions about value, return, or price paid. Building net operating income moves through defined stages. Start with potential gross income at full occupancy. Subtract vacancy and collection loss to get effective gross income. Then subtract operating expenses to arrive at net operating income. The exclusions matter more than the inclusions. Mortgage, principal, and interest are not operating expenses, and neither is depreciation, capital improvements, or the owner's income taxes. Debt service is excluded on purpose, because net operating income must describe the property, not the buyer's financing. The capitalization rate is pulled from the market, not invented, and it carries the market's judgment about risk. Apply a higher rate to identical income and value falls, because investors demanding more return pay less for the same earnings. Question 29. A newly licensed sales associate in Jacksonville is approaching the end of her first license period. She has completed no education at all since passing the state examination. What happens if she simply pays the renewal fee and keeps working? Your options are A. The license converts to voluntarily inactive. B. The license becomes null and void. So the renewal is delayed 90 days. D. A citation and fine are issued. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B. The license becomes null and void. B is correct because a sales associate who fails to complete the required post-licensure education before that first renewal holds a license that is considered null and void. Section 425.17 Florida Statutes states that consequence plainly. A is wrong because voluntarily inactive is a status a licensee chooses, while remaining fully eligible to reactivate later. Missing the post-licensure requirement produces a far harsher outcome than a simple change of status. C is wrong because no 90-day grace period softens this requirement anywhere in the statute. The education must be finished before that first renewal arrives rather than shortly after the deadline passes. D is wrong because a citation addresses minor rule violations that pose no substantial threat to the public health, safety, or welfare. This failure extinguishes the license itself instead of drawing a fine. Null and void is the harshest status in Florida real estate license law, and it needs no hearing and no complaint. It simply happens by operation of law when a new sales associate finishes her first license period without completing post-licensure education. The trigger is specific. A sales associate must complete 45 hours of post-licensure education before the first renewal, while a broker needs 60 hours. That first license period runs an irregular 18 to 24 months because Florida renewal dates follow a fixed cycle, not the date each person got licensed. Florida law uses 4 distinct status words. Void means the license no longer exists, with no proceeding involved. Involuntarily inactive means the license still exists and can be reactivated. Suspended is a temporary disciplinary penalty capped at 10 years. And revoked means the commission has permanently taken the license away. Compare that to an experienced licensee who misses 14 hours of continuing education every 2 years. Her license just goes involuntarily inactive, and she can reactivate. The new licensee who skips post-licensure education gets no such mercy, because that education is the state's substantive competency check, and there is no reinstatement, no late fee, and no hardship provision to undo it. Recovering from a void license means retaking the 63-hour pre-license course, reapplying, and passing the state exam again from scratch, since closed transactions never substitute for the missed education. A stem naming a first license period with no post-licensure education has already told you the license is void, not inactive. Question 30. A buyer in Sarasota records her deed in the county public records the same afternoon her sale closes. Her licensee explains that recording accomplishes something specific for every later purchaser or creditor who deals with that property. What does it accomplish? Your options are: A. It gives constructive notice to everyone. B. It guarantees the title is marketable. C. It transfers ownership from seller to buyer. D. It removes liens recorded earlier. Which would you go with? Lock it in before the reveal. The correct answer is A. It gives constructive notice to everyone. A is correct because recording places the instrument in the public records so that everyone is charged with knowledge of it, whether or not they actually search. That constructive notice protects the buyer against later claimants. B is wrong because marketability depends on the condition of the title itself, which a title search and title insurance are designed to address. Filing a defective deed leaves every existing defect exactly where it was. C is wrong because title passes on delivery and acceptance of the deed, which happened at the closing table. Recording protects an interest that has already been transferred rather than creating the transfer itself. D is wrong because earlier recorded liens keep their priority and their place in line ahead of later claims. Recording a deed announces the change of ownership but clears nothing off the public record. Nothing stops an owner from signing 2 deeds to 2 different buyers on 2 different days. Recording exists to make that mess avoidable. By creating a public record, any buyer can search before paying. 3 kinds of notice work together. Actual notice is what you genuinely know. Constructive notice charges everyone with knowledge of what's recorded, whether they looked or not. Inquiry notice means a tenant living in the house triggers a duty to ask questions, recorded or not. Recording means depositing the deed with the clerk of the circuit court in the county where the land sits, where it gets indexed and made permanently searchable, that act triggers constructive notice. The whole world is now charged with knowledge of it, whether or not anyone actually looks. Recording does not transfer title, since delivery and acceptance of the deed do that. It does not make a forged deed valid, and it is not required for the deed to bind the grantor and grantee to each other. Its entire job is protecting the grantee against everyone else. Florida rewards diligence over timing. An unrecorded deed is void against a later buyer who pays value without notice. That's why recording the same afternoon a sale closes is the most protective move a buyer can make. Question 31. A contract on a Daytona Beach home collapses, and both the buyer and the seller make written demands for the escrow deposit. The broker holding the money knows that two separate deadlines now run against her. Which pair of deadlines applies? Your options are A. 10 business days, then 20 more. B. 15 calendar days, then 30 more. C. 15 business days, then 30 more. D. 30 business days for both steps. Don't overthink it. Which one feels right? The correct answer is C. 15 business days, then 30 more. C is correct because the broker must notify the commission in writing within 15 business days of the last demand and must institute one of the 4 settlement procedures within 30 business days. Rule 61J210 Florida Administrative Code. A is wrong because those shorter periods match no escrow deadline in Florida. 10 business days does appear elsewhere in the rules, tied to a dispute that settles or reaches court before a disbursement order issues. B is wrong because the deadlines are counted in business days rather than calendar days, and that distinction matters whenever a holiday weekend falls inside the window. Calendar counting would quietly shorten the broker's working time. D is wrong because the 2 steps run on separate clocks rather than a single one. Notification comes first and quickly, and the broker then has a longer stretch to choose among the settlement procedures. When 2 parties both demand the same escrow money, the broker has no authority to pick a winner. Deciding on her own risks a conversion claim, while sitting on the funds forever risk a failure to account charge. Florida solves this by taking the decision out of her hands entirely. The procedure runs on 2 separate clocks, both counted in business days from that last demand. Within 15 business days, the broker must notify the Florida Real Estate Commission that a dispute exists. Within 30 business days, she must institute one of the settlement procedures, and satisfying one deadline never satisfies the other. 4 procedures are available, and they differ in who ultimately decides. Mediation is non-binding and needs both parties' written agreement. Arbitration is binding, also by written agreement. An escrow disbursement order asks the commission itself to direct the funds. An interpleader asks a court to sort out the claimants instead. The escrow disbursement order carries a powerful protection. A broker who disburses funds in compliance with a commission order is shielded from liability to either party, even if that order later turns out to be wrong. The commission accepted the risk of an incorrect decision, so brokers would stop making these calls themselves. And Florida even provides for reimbursement of attorney fees when a party sues over a followed order. Not every disagreement triggers this machinery. If the contract already authorizes release, or only one party has demanded, or the dispute resolves before deadlines run, the broker just follows the facts. But once 2 written demands truly conflict, no matter how obvious the merits seem, the broker may never decide the dispute herself and hand over the check. Question 32. A purchase contract on a Naples home states that if the buyer defaults, the seller may keep the deposit as full compensation, and that neither party may sue for anything beyond that amount. Which contract provision does this describe? Your options are A. Specific performance, B. Liquidated damages, C. Rescission, D. Novation. Got a guess? Lock it in. The correct answer is B, liquidated damages. B is correct because A, liquidated damage clause, fixes in advance what the injured party may keep or collect if the other side breaches, which closes off any later claim for actual losses proven at trial. A is wrong because specific performance is a court remedy compelling a party to complete the sale itself rather than pay money. This clause points in the opposite direction by settling the dispute with cash already on deposit. C is wrong because rescission cancels the contract and returns both sides to the positions they held beforehand, which normally means giving the deposit back. Here the seller keeps that money instead. D is wrong because novation substitutes a new party or a new agreement for the original one with everyone's consent. Nothing in this clause replaces either the parties or the contract they signed. Proving real losses after a broken real estate contract is slow, costly, and uncertain. That's why contracts often replace that whole fight with one number agreed on in advance, liquidated damages. Courts won't enforce these clauses automatically. First, the damages must have been genuinely hard to estimate when the contract was signed. Second, the amount must be a reasonable forecast of loss, not a punishment. A clause letting a seller keep half the purchase price would be struck down as a penalty. In Florida residential contracts, the earnest money deposit sitting in escrow is commonly designated as the liquidated damages if the buyer defaults, turning an uncertain lawsuit into a simple retention of funds already on hand. 4 remedies compete for the same slot. Compensatory damages restore actual proven loss. Liquidated damages substitute an agreed figure for that proof. Specific performance forces the sale to close, since land is unique. Rescission, a fourth option, unwinds the deal entirely for defective formation rather than breach. Naming a sum as full compensation cuts both ways. A seller who keeps the deposit can't later sue for additional losses, even provable ones, and electing to keep the deposit waives specific performance because one treats the contract as dead and the other as alive. Question 33. A homeowner in Hialeah loses a foreclosure suit and the property is sold at a public sale conducted by the clerk. How much time does Florida still give her to redeem the property by paying what she owes? Your options are A. 1 year after the sale, B. 6 months after the sale, C. Until the purchaser records the deed, D. Until the certificate of sale is filed. Which one is it? Pause the video if you need more time. The correct answer is D. Until the certificate of sale is filed. D is correct because Florida permits redemption at any time before the later of the clerk's filing of the certificate of sale or the time specified in the judgment. No statutory redemption period follows the sale. Section 48315 Florida Statutes. A is wrong because a year-long right to redeem after the sale belongs to states that grant a statutory redemption period. Florida cut the right off at the sales stage, which is why purchasers there receive clear title quickly. B is wrong because 6 months is likewise a redemption period borrowed from other jurisdictions. Adopting it in Florida would leave foreclosure purchasers holding uncertain title for half a year after they paid. C is wrong because waiting until the certificate of title is recorded would stretch the right past the statutory cutoff. Filing the certificate of sale is the earlier event, and that filing is what closes the window. In a Florida foreclosure, one filed document ends the borrower's chance to save the property. Understanding exactly which document and why is the key to this entire topic. The clerk files the certificate of sale right after the auction, which records the winning bid and opens a short objection window. Only after that window closes does the clerk issue the certificate of title, the document that actually transfers ownership. 3 vocabulary terms drive every exam question here. Reinstatement means curing the arrears before acceleration, the earliest chance. Equitable redemption means paying the full accelerated balance before the sale is final, which Florida allows. Statutory redemption, a post-sale window most other states grant, Florida simply does not have. Picture the auction ending, the clerk filing the certificate of sale, and that filing acting as a locked gate behind the former owner. Any objection to the sale must happen in the narrow window that follows, before the certificate of title makes the new owner's rights final. Florida trades a borrower's post-sale second chance for a market where bidders compete seriously, which protects the borrower's equity up front instead. Remember, the redemption window closes the moment the certificate of sale is filed, and no statutory redemption follows in Florida. Question 34. A property manager in Tampa tells a family with 2 young children that the owner would prefer to rent the unit to a couple with no children living at home. Which protected class does that preference violate under Florida's fair housing law? Your options are A. National origin, B. Marital status, C. Familial status, D. Age. Take a second. Which answer would you pick? The correct answer is C. Familial status. C is correct because familial status protects households that include children under 18, along with pregnant persons and those securing custody. Steering a family away from a unit on that basis violates the Florida Fair Housing Act. Section 76823 Florida Statutes. A is wrong because national origin concerns the country a person or that person's ancestors came from. Nothing in the manager's statement turns on where this particular family originated or what language they speak. B is wrong because marital status is not among the 7 classes the Florida Act protects. Although some local ordinances do add it, the refusal here was aimed squarely at the children rather than at the couple. D is wrong because age standing alone is not a protected class under the Fair Housing Statute, and lawful housing for older persons is expressly accommodated. The presence of the children is what triggered this refusal. The Fair Housing Act protects 7 classes that arrived in 3 waves: race, color, religion, and national origin in 1968, sex in 1974, and handicap and familial status in 1988. Florida's own Fair Housing Act mirrors this list, so a violation there is usually a violation of both laws. Familial status is the least intuitive class because its name doesn't announce what it covers. It protects households with a child under 18 living with a parent or legal custodian, a pregnant person, and someone in the process of securing legal custody of a minor. That means expectant couples and prospective adoptive parents are protected before any child is even in the home. Violations range from blunt to subtle. Refusing to rent to a family is the obvious one, but steering families towards certain buildings or floors is quieter and easier to miss. Advertising phrases like adults preferred, tight occupancy standards, and rent differentials for families with children all violate the Act on its face. One major exemption exists: housing for older persons may lawfully exclude families with children. A community can qualify if every resident is 62 or older, or if at least 80% of units house someone 55 or older, backed by policies and age verification. This works because age itself is not a protected class in housing. If it were, senior communities couldn't exist. Enforcement deadlines differ by route. An administrative complaint with HUD or the Florida Commission on Human Relations must be filed within 1 year, while a private civil action allows 2. Remedies include damages, injunctive relief, and attorney fees. And a licensee also faces discipline from the Florida Real Estate Commission, regardless of what the owner instructed. Question 35. A couple attending a sales presentation in Kissimmee signs a contract that afternoon to buy a timeshare week at a resort. On the drive home, they regret the purchase. How long does Florida give them to cancel it? Your options are A. 3 calendar days, B. 5 business days. C. 7 business days. D. Until midnight of the 10th day. Before I reveal it, which one do you think is right? The correct answer is D. Until midnight of the 10th day. D is correct because a timeshare purchaser may cancel until midnight of the 10th calendar day after execution or receipt of the last required document, whichever is later, and that right cannot be waived. Section 721.10 Florida Statutes. E is wrong because 3 calendar days is the window attached to the Homeowners Association disclosure summary. Timeshare buyers receive a considerably longer period because of the pressured way those sales are often presented. B is wrong because 5 business days matches no cancellation right in the Florida chapter governing vacation plans and timeshares. That chapter counts calendar days, so the business day framing is wrong here entirely. C is wrong because 7 business days is the condominium resale window created for unit sales between private owners. Timeshare interests are governed by their own chapter, which sets a different and longer period. Florida law gives timeshare buyers something almost no other purchaser gets: a guaranteed second chance to walk away. No excuse required. 2 things make this rule unusual. The count runs in calendar days, so weekends and holidays are included, and the clock starts at the later of 2 events: signing or receiving the full paperwork. A delayed disclosure extends the buyer's window rather than shrinking it, and no clause in the contract can waive this right away. The interest a buyer actually gets comes in 2 forms. A deeded timeshare is real property, recorded and inheritable like a house. A right to use timeshare is only a license to occupy for a set term, personal property that simply expires. Both are covered by the same 10-day right, but they behave very differently for taxes, financing, and inheritance. The legislature focused on what a timeshare purchase truly commits a buyer to. Maintenance fees continue indefinitely and rise. Special assessments hit owners just like condominium assessments do, and the resale market is so thin that a buyer who regrets the deal years later may not be able to sell at any price. Compare that to an ordinary home purchase, where a buyer has no statutory right to cancel at all, only whatever contingencies the contract happens to include. Florida decided the resort sales room produces decisions that regular contract law shouldn't have to honor, and wrote this protection directly into the statute. Question 36. A sales associate in Orlando prepares a written opinion of value for a lender's asset manager and is paid a fee for that work. She holds no appraiser credential of any kind. What does Florida law permit her to call the document? Your options are A. A limited appraisal report. B. A restricted appraisal. C. A broker price opinion. D. A certified valuation. What's your answer? Commit to one before I continue. The correct answer is C. A broker price opinion. C is correct because Florida allows a licensed broker, broker associate, or sales associate to provide valuation services for compensation, but the resulting work product may not be referred to or construed as an appraisal. Section 475-612 Florida Statutes. A is wrong because anything labeled an appraisal, even a limited one, requires certification or licensure under the appraisal part of the chapter. The label itself is what the statute places off limits to her. B is wrong because restricted appraisal reports are a report type defined in appraisal standards and available only to credentialed appraisers. A real estate licensee without that credential cannot issue one under any name. D is wrong because certified describes an appraiser's credential level rather than a document a real estate licensee may produce. Using that word would misrepresent her authority and invite a disciplinary complaint. Florida draws a sharp line through property valuation, and it's not about who can form an opinion of value. It's about what that opinion is allowed to be called. State law lets a broker or sales associate analyze comparable sales, apply adjustments, and produce a paid written opinion of value. What she may never do is call that document an appraisal, because appraisal is its own separately regulated profession with its own board and its own licensing tiers. The vocabulary needs sorting too. Market value is the most probable price in a fair, open sale. Assessed value is the county property appraiser's figure for taxation, capped by homestead rules. Insured value covers only replacement cost of improvements, excluding land entirely. The two common products differ by audience, not method. A comparative market analysis serves a seller or buyer, usually free. A broker price opinion serves a lender or asset manager, usually paid, evaluating distressed or bank-owned property. Federal law even bars using one as the primary basis for an original mortgage. A licensee can be paid to produce a broker price opinion for a lender and stay perfectly lawful. The moment she titles it an appraisal, she's violated the license law, no matter how good the analysis is. Question 37. A licensee in Cape Coral pulls the legal description for a new listing and finds a reference to a numbered parcel within a recorded subdivision map that was filed with the county years ago. Which method of legal description is being used? Your options are A. Lot and block, B. Meets and bounds, C. Rectangular survey, D. Monument description. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Lot and block. A is correct because the lot and block method identifies property by its number on a recorded subdivision plat, and the plat itself supplies the detailed boundary information. It is the most common description in platted communities. B is wrong because meets and bounds traces the perimeter of a parcel using directions and distances from a point of beginning. A short reference to a recorded plat replaces that much longer recital entirely. C is wrong because rectangular survey descriptions name townships, ranges, and sections rather than lots inside a subdivision. That system covers land the federal government surveyed into a grid long before development. D is wrong because monument descriptions rely on physical markers such as trees, stakes, or iron pipes to fix boundaries. Recorded plats are far more precise and do not depend on objects that rot or get moved. A subdivision plat is a survey drawing that becomes a legal document once a surveyor lays out lots and blocks and the county records it. From that moment, every parcel inside it can be identified just by pointing to the plat. That reference is the lot and block system, also called the recorded plat method. A complete description names the lot, the block, the subdivision, the plat book and page, and the county, while the recorded plat itself holds every measurement a surveyor would need. The plat itself shows lots grouped into blocks, along with streets, alleys, drainage areas, and utility easements all drawn to scale. Recording it dedicates those streets and easements to public and utility use, so a buyer takes title subject to everything the plat shows. The clean way to tell the three methods apart is to ask where the detail is stored. In lot and block it sits on a recorded plat. In meets and bounds it's carried inside the description itself. And in the rectangular survey it comes from an independent federal grid of townships and sections. A short lot and block deed isn't less precise. It's just borrowing detail that was already recorded permanently by a licensed surveyor. Any change, like splitting or combining lots, needs its own recorded replay, or a title examiner will question it. Question 38. A licensee in Vero Beach is preparing a sale and purchase contract and must include the statutory notice about a naturally occurring radioactive gas that has been found in Florida buildings. When must the buyer receive that notice? Your options are A. Only if the buyer requests testing, B. Within 10 days after the closing, C. Only for homes of a certain age, D, at or before execution of the contract. Which would you go with? Lock it in before the reveal. The correct answer is D, at or before execution of the contract. D is correct because the radar notice must appear on at least one document delivered to the buyer at or before execution of the contract for sale or a rental agreement. Section 404.056 Florida statutes requires it. A is wrong because the notice is mandatory rather than something the buyer has to ask for. Its whole purpose is warning buyers who would never think to raise the subject on their own. B is wrong because delivering the notice after closing would defeat the point of warning a buyer before she becomes committed to the purchase. The statute ties delivery to the moment of contracting instead. C is wrong because the requirement carries no construction age cutoff whatsoever. An age threshold of that kind belongs to the federal lead-based paint rule, which reaches only residential housing built before a stated federal deadline. Radon is a colorless, odorless radioactive gas that seeps up from soil and rock and collects in enclosed buildings, where long-term exposure makes it the second leading cause of lung cancer in the United States. Florida's slab-on-grade construction and tightly sealed homes make this an especially serious concern statewide. Radon rises from the ground and enters through cracks in the slab, foundation joints, sump openings, and utility penetrations. Once inside a tightly sealed, air-conditioned house, it has nowhere to disperse, unlike outdoors where it harmlessly scatters. Florida law does not require anyone to test for radon or fix an elevated reading. It simply requires that a specified notice appear on a document executed at or before the contract for sale or rental agreement, stating that radon exists, may pose health risks, has been found above guidelines in Florida, and that the county health unit can provide more information. Florida transactions carry 3 distinct duties that are easy to confuse. The radon notice applies statewide regardless of what anyone knows. The federal lead-based paint disclosure applies only to pre-1978 housing, with a pamphlet and inspection period, and the Johnson versus Davis duty requires disclosing known material defects that aren't readily observable. Remember, the radon notice is informational, applies to sales and rentals alike, and must appear at or before execution of the contract, no matter where in Florida the property sits. Question 39. A broker in West Palm Beach lists a home and then meets a buyer who wants that very property. He proposes representing both parties fully and disclosing the arrangement in writing to each of them. What does Florida law say about his plan? Your options are: A. Dual agency is prohibited in Florida. B. It is allowed with written consent. C. It is allowed only in commercial deals. D. It is allowed if parties are related. Don't overthink it. Which one feels right? The correct answer is A. Dual agency is prohibited in Florida. A is correct because Florida flatly bars Alliance and Z from operating as a disclosed or non-disclosed dual agent. The transaction broker relationship exists precisely so that one brokerage can lawfully assist both sides. Section 475.278 Florida statutes. B is wrong because written consent cures a great many things in Florida practice, but it cannot cure this. The statutory prohibition is unqualified, so no signature from either party can authorize the arrangement. C is wrong because the ban reaches every transaction type in the state. Non-residential deals meeting a high asset threshold may use designated sales associates, which is a distinct mechanism with its own requirements. D is wrong because family relationships between the buyer and the seller change nothing at all. The statute looks at the roles the licensee is attempting to occupy rather than at how the parties know each other. Florida prohibits dual agency outright with no exceptions. Not disclosed, not undisclosed, and not even with written consent from every party involved. This unconditional ban under Florida Statute 475.278 makes elaborate consent procedures a trap, rather than a solution on the exam. The reasoning is structural, not moral. A single agent owes loyalty, obedience, confidentiality, and full disclosure to one principal. Try to owe all of that to a buyer and a seller at once, and the duties cancel each other out. Instead of banning brokerages from working both sides, Florida created transaction brokerage, a lesser, honest relationship with limited confidentiality and no promise of loyalty to anyone. The only exception is the designated sales associate arrangement, reserved for non-residential deals with million-dollar parties who request it in writing. In this narrow exception, the brokerage itself is never the dual agent. The broker designates one associate to represent the buyer alone and a different associate to represent the seller alone, each owing full loyalty to only one side. Most states allow disclosed dual agency with informed consent, and licensees moving from those states often assume Florida works the same way. It doesn't. In Florida, there is nothing disclosure can cure. Question 40. A veteran in Jacksonville qualifies for a loan guaranteed by the Department of Veterans Affairs. Her lender explains the single feature that most clearly distinguishes this program from a conventional loan on the same house. Which feature is it? Your options are: A. The government sets the interest rate. B. Private mortgage insurance is always required. C. The property must be newly built. D. No down payment within the entitlement. Got a guess? Lock it in. The correct answer is D. No down payment within the entitlement. D is correct because the defining benefit of a guaranteed veterans loan is that a qualified borrower can finance the purchase with no down payment at all, up to the amount the guarantee entitlement supports. A is wrong because interest rates are negotiated between the lender and the borrower in the open market. The agency guarantees a portion of the loan and leaves pricing entirely to the parties. B is wrong because private mortgage insurance belongs to conventional lending when the down payment is small. The government guarantee takes its place in this program and a one-time funding fee applies instead. C is wrong because existing homes qualify freely under the program, and most veterans buy them. Restricting the guarantee to new construction would exclude the great majority of the housing stock in Florida. The Department of Veterans Affairs never actually lends money. A private lender funds the loan, and the government simply guarantees a slice of it against default. That guarantee acts as a substitute for a down payment, not a subsidy of one. Because the lender's risk is already covered by the government, the equity requirement simply disappears, letting a qualified veteran finance the full purchase price. Coverage is measured in entitlement. Each veteran has a basic entitlement. Lenders once extended roughly 4 times that with no down payment, and full entitlement now removes the loan limit altogether, leaving qualification as the only real ceiling. Picture the loan as layers. The property value at the base, the loan balance stacked on top, and the VA guarantee covering that top slice where a down payment normally goes. The lender is protected, so the veteran isn't required to put money down. Sorting loans by the government's role makes everything click. Guaranteed VA loans skip mortgage insurance entirely. Insured FHA loans require it, and conventional loans price risk purely through rate and private insurance. The VA's one-time funding fee, waivable for service-connected disability, stands in for that missing insurance. Question 41. A broker in Sarasota keeps a cushion of her own money in each trust account to cover bank service charges. What does Florida permit her to hold in the sales escrow account and in the property management account? Your options are: A. The same amount in each account. B. 1,000 sales, 5,000 management. C. 5,000 sales, 1,000 management. D. No personal funds in either account. Which one is it? Pause the video if you need more time. The correct answer is B. 1,000 sales, 5,000 management. B is correct because a broker may hold up to $1,000 of personal or brokerage funds in the sales escrow account and up to $5,000 in the property management escrow account. Section 47525 Florida statutes. A is wrong because the two accounts carry different ceilings because property management involves recurring bank activity across many owners and many months. Treating both accounts identically misreads the statute and risks a commingling charge. C is wrong because the two figures are reversed here. Property management accounts receive the larger cushion, and moving that larger amount into a sales escrow account would put the broker over the statutory limit. D is wrong because a flat prohibition would leave brokers unable to cover routine service charges without dipping into money belonging to their customers. The statute deliberately permits a limited cushion in each account. Banks charge monthly service fees, and if an escrow account holds only client money, those fees quietly push the bounds below what the broker actually owes. No one stole anything, but the account is still short, and a shortage is a violation no matter how it happened. Florida solves this with a controlled exception. A broker may keep a small amount of her own money in each escrow account specifically to absorb bank charges, and that permission is narrow with amounts fixed by law. The sales escrow account caps the personal cushion at $1,000 since it holds a handful of deposits sitting quietly until closing. The property management account allows up to $5,000 because rent collections, owner payouts, vendor payments, and security deposits generate far more monthly activity and fees. Exceeding those limits is commingling, a violation on its own even if every client is paid on time. Because separation is what keeps trust money traceable, conversion is worse, actually using trust funds for the broker's own purposes. Commingling creates the conditions for conversion, which is why the law punishes the first before waiting for the second. This topic really tests three things. Deadlines govern when money must move, limits govern what a broker may keep alongside client funds, and reconciliation is the written proof that both were honored. A cushion for bank fees lives inside the limits rule, and its size depends entirely on which account you're managing. Question 42. A man has openly occupied and maintained a vacant lot in Polk County for years, treating it as his own without the record owner's permission. How long must such possession continue in Florida before a claim can ripen into title? Your options are A. 3 years, B. 5 years, C. 10 years, D. 7 years. Take a second. Which answer would you pick? The correct answer is D. 7 years. D is correct because both forms of adverse possession in Florida, with color of title and without it, require 7 years of continued possession. Sections 9016 and 9518 Florida statutes set that identical period for each form. A is wrong because 3 years is far shorter than any Florida possession period and would allow claims to mature before most absentee owners ever noticed that someone had moved onto their land. B is wrong because 5 years is the limitations period for suing on a written contract, which comes from an entirely different statute. Possession claims against a record owner run on their own separate clock. C is wrong because 10 years is the period a number of other states use for adverse possession. Florida settled on a shorter one, and a claim without color of title also demands payment of all outstanding taxes. Handing land to a trespasser can feel like the law rewarding bad behavior, but adverse possession isn't a prize for stealing land. It's a statute of limitations doing exactly what statutes of limitations do, applied to an owner's right to evict an occupant. The real reason is about titles, not about rewarding anyone. if ownership could be challenged from any point in the distant past, fences drifting and old deed errors would cloud huge portions of every county's records. So the law converts long-standing physical reality into settled legal reality. Florida requires 5 elements over 7 years. Possession must be actual, open and notorious, hostile, meaning without permission, exclusive and continuous for the entire period without interruption. Florida recognizes 2 versions, both running 7 years. A claim with color of title relies on a defective deed and extends to the whole parcel it describes, while a claim without color of title is much harder, demanding paid taxes, a filed return with the property appraiser, and visible enclosure or cultivation. 2 more rules matter. Tacking lets successive owners connected by deed or inheritance add their time together, and government land can never be adversely possessed. Don't confuse this with a prescriptive easement, which takes 20 years and grants only a use right, not ownership, while an encroachment or squatter simply hasn't run the clock yet. Question 43. A licensee preparing study material for her post-license course wants to state correctly how the Florida Real Estate Commission is put together, how many members it has, and who places those members in office. Which statement is accurate? Your options are A. 9 members elected by licensees statewide, B. 7 members appointed by the governor, C. 5 members chosen by the department secretary, D. 11 members appointed by the Senate. Before I reveal it, which one do you think is right? The correct answer is B. 7 members appointed by the governor. B is correct because the commission has 7 members appointed by the governor and confirmed by the Senate, including 4 brokers, 1 broker or sales associate, and 2 consumer members. Section 475(2) Florida statutes sets that structure. A is wrong because licensees do not elect the commission, and the membership is 7 rather than 9. 2 of those seats are reserved for consumer members who have never held a real estate license at all. C is wrong because the department secretary appoints the director of the Division of Real Estate, subject to approval by the commission. The commission members themselves are appointed by the governor instead. D is wrong because the Senate confirms these appointments rather than making them, and the statute fixes the membership at 7. An 11-member board would also change every quorum calculation the Commission performs. The Florida Real Estate Commission's powers make sense once you see where it sits in the state structure. It is not a standalone agency, but a policy and discipline body operating inside a larger administrative chain. The legislature writes the license law in Chapter 475. The Department of Business and Professional Regulation administers, investigates, and prosecutes. The Division of Real Estate is the department's unit for this profession, and the Commission adopts rules and decides cases within that structure. 7 members appointed by the governor and confirmed by the Senate, split 5-2 between industry and consumers. This ratio is a deliberate compromise. Professional self-regulation works best when practitioners write practical rules, but it needs outside eyes to keep those rules honest. Staggered 4-year terms keep policy stable instead of swinging wildly with every new commission. The commission's power splits into quasi-legislative rulemaking and quasi-judicial adjudication, but it cannot write statutes, award damages, or bypass the Administrative Procedure Act's notice and hearing requirements. When a question asks who appoints the commission or what it can decide, remember the chain: legislature, department, division, commission, each with a distinct and limited role. Question 44. A closing on a home in Winter Haven takes place in September, and the county property taxes for that year will not be billed until November. How should the settlement agent handle the taxes that accrued while the seller owned the property? Your options are A. Credit the buyer and debit the seller, B. Credit the seller and debit the buyer. C. Charge both parties an equal share. D. Ignore them until the bill arrives. What's your answer? Commit to one before I continue. The correct answer is A. Credit the buyer and debit the seller. A is correct because taxes that have accrued but are not yet payable belong to the seller for the months she owned the home. These sum van sorted raise. So the statement debits the seller and credits the buyer who will pay the bill. B is wrong because reversing the two entries would hand the seller money for a tax bill the buyer must actually pay in November. The accrued portion covers a period before closing and belongs to the seller. C is wrong because splitting the charge evenly ignores how many months each party actually owned the property during that tax year. Proration exists to divide an expense by time, not by head count. D is wrong because leaving the item of the statement entirely would send the buyer a full year tax bill covering months when she did not own the home. Closing is the moment to square that up. Every settlement statement mismatch comes down to one question. Is the item paid in arrears or paid in advance? Florida property taxes are the classic arrears example, and understanding that direction unlocks every proration on the exam. Florida taxes are levied for the calendar year but assessed on January 1st, and the bill isn't mailed until November 1st, due through the following March. A closing in September lands in a 9-month gap where tax has been accruing all year, but no bill exists yet. Because the buyer will receive the entire November bill and pay for months she didn't own the home, the settlement statement fixes the mismatch with a paired entry. The seller's accrued share is debited from her proceeds and credited to the buyer. No money changes hands at closing. The buyer simply holds the seller's share until the real bill comes due. Group everything into two buckets instead of memorizing line items, arrears items, like property taxes and accrued loan interest, flow toward the buyer as a debit to the seller and credit to the buyer. Advance items, like prepaid HOA dues and assumed insurance, flow the opposite way, crediting the seller and debiting the buyer. Rent behaves like an advance item too, which is why it can prorate opposite to taxes on the same statement. When a September closing hits a tax bill that isn't due until November, the accrued taxes are a debit to the seller and a credit to the buyer. Arrears always flow toward whoever pays next. Question 45. An investor in Fort Myers buys a rental duplex using a small amount of her own cash and a large mortgage, expecting that the property's return will comfortably exceed her borrowing cost. Which investment principle is she relying on? Your options are A. Assemblage, B. Amortization, C. Leverage, D. Eshat. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Leverage. C is correct because leverage is the use of borrowed money to control a larger asset, and it magnifies the return on the investor's own cash whenever the property performs better than the cost of the debt. A is wrong because assemblage joins adjoining parcels under one ownership to create value greater than the sum of the separate pieces. This investor bought a single duplex and combined nothing with anything. B is wrong because amortization describes paying loan principal down on a fixed schedule over time. It steadily builds equity for an owner, but does not explain why she chose to borrow so heavily in the first place. D is wrong because escheat is the state's claim to property when an owner dies, leaving neither a will nor any heirs. It has no bearing whatsoever on how an investment purchase gets financed. Two investors buy identical duplexes for the same price. One pays cash, the other borrows most of it. When the property appreciates 10%, the cash buyer earns 10% on her money, but the borrower earns roughly 40% on hers, because the same gain is measured against a much smaller cash base. That is leverage, using borrowed money to control an asset larger than your cash alone could buy, which magnifies the percentage return on the money you actually invested. Positive leverage exists when the property's return exceeds the cost of borrowing, so every borrowed dollar adds a spread to your equity. Negative leverage flips that. Borrowing at 7% against a 5% return means each borrowed dollar drains your return instead. The symmetry matters. Leverage magnifies losses exactly as it magnifies gains. If the properties fell 10% instead, the cash buyer would lose 10% while the leveraged buyer could lose around 40%, because debt service stays fixed even when income or value does not. Leverage is one of 4 sources of return in real estate, alongside cash flow, appreciation, and equity buildup. But leverage itself produces nothing. It simply amplifies whatever those 3 produce in either direction. Question 46. A sales associate in Miami closes a difficult transaction, and the grateful seller offers to write her a personal check for her extra effort, entirely separate from the brokerage commission. What does the Florida license law say about accepting that check? Your options are: A. She may accept if she reports it. B. She may accept if it is small. C. She may accept it once closing occurs. D. Only her registered employer may pay her. Which would you go with? Lock it in before the reveal. The correct answer is D. Only her registered employer may pay her. D is correct because a sales associate may not collect money in connection with a brokerage transaction, except in the name of her employer and with the employer's consent, and may sue only that employer for compensation. Section 47542 Florida Statutes. A is wrong because reporting the payment to the broker afterward does not cure the violation. The statute controls who is permitted to pay the associate rather than who eventually learns that a payment was made. B is wrong because the prohibition carries no minimum dollar threshold at all. A modest cash gift for brokerage services runs into exactly the same statutory provision as a large one would. C is wrong because the timing of the payment changes nothing either, whether the money moves before or after the closing. It still reaches the associate from someone other than her registered employer. Florida law allows a sales associate to be paid by exactly one party, the broker she is registered under. There are no exceptions for gratitude, bonuses, or an insistent client. The statute is strict. An associate may not collect money except in her broker's name and with the broker's express consent, and she can't sue anyone else for compensation. This single section carries both disciplinary and criminal weight. Picture the money's path. The customer pays the brokerage, and the brokerage pays its own registered associate. A direct line from customer straight to associate breaks that chain and breaks the law, even if the payment is a well-meaning gift. 3 routes are always lawful: customer to brokerage, brokerage to its own associate, and brokerage to another brokerage. Payment straight to another broker's associate or to an unlicensed person for licensed work breaks the rule. Whenever a question describes money moving in a real estate transaction, trace the chain. If it skips the broker, it's a violation, no matter how generous the intent. Question 47. A licensee in Orlando notices that mortgage rates across the market shifted after the nation's central bank changed the rate it charges member banks for short-term borrowing. Which body took that action and set those changes in motion? Your options are: A. The Federal Housing Administration, B. The Federal Reserve, C. The Federal Home Loan Mortgage Corporation, D. The Department of Housing and Urban Development. Don't overthink it. Which one feels right? The correct answer is B. The Federal Reserve. B is correct because the Federal Reserve manages the nation's money supply and credit conditions. and its adjustments to the discount rate and to open market operations ripple outward into mortgage pricing for consumers. A is wrong because the Federal Housing Administration insures residential loans made by approved lenders and sets underwriting standards for them. Insuring individual mortgages is a far narrower job than steering national credit policy. C is wrong because that corporation buys loans in the secondary market and packages them into securities for investors. It responds to prevailing credit conditions and never sets the rates that create them. D is wrong because the Housing Department administers federal housing programs and enforces fair housing law across the country. Setting the discount rate sits well outside the authority Congress gave that agency. The Federal Reserve does not set mortgage rates. It controls the cost and quantity of money in the banking system, and that influence has to travel through a chain of steps before it ever reaches a lender's rate sheet. 3 tools do the work. The discount rate charges member banks for direct borrowing. Reserve requirements control how much banks can lend, and open market operations, the most powerful tool, buy or sell securities to inject or drain money. All 3 serve the Fed's dual mandate of maximum employment and stable prices. Changing the cost of money moves short-term rates, which move the yield on the 10-year Treasury note. Mortgage-backed securities compete with treasuries for investor dollars. So lenders price mortgages off what those securities will sell for, plus their own margin. This is why mortgage rates sometimes move opposite a Fed announcement. An anticipated cut is already priced in, and a cut signaling economic worry can even push long-term yields up. The real distinction is between monetary policy, which belongs to the Fed, and fiscal policy, insurance, and guarantees, which belong to Congress, the FHA, the VA, and the secondary market. Housing feels monetary policy earlier and harder than almost any other industry, but the Federal Reserve is only the first link in a long chain that ends at your lender's rate sheet. Question 48. A sales associate in Miami lets her license lapse and does nothing about it for a year and a half. She now wants to return to active practice. What does the license law require of someone inactive for that long? Your options are A. 28 hours of prescribed education, B. Retaking the state license and examination, C. 14 hours of continuing education, D. Nothing beyond paying the renewal fee. Got a guess? Lock it in. The correct answer is A. 28 hours of prescribed education. A is correct because a licensee who has been involuntarily inactive for more than 12 but fewer than 24 months must complete 28 hours of commission-prescribed education to reactivate. Section 475(1)(d)(3), Florida statutes sets that requirement. B is wrong because the examination comes back into the picture only after a license has expired and become void, which happens once involuntarily inactive status runs past 2 years. She is still inside that window. C is wrong because 14 hours covers a licensee who has been involuntarily inactive for 12 months or less. Her longer absence from practice moves her up into the higher education requirement. D is wrong because paying the fee alone would let a licensee sit out years of practice and return with no refresher at all. Education scaled to the length of the absence is the entire point of the provision. Florida license status works like a ladder, not a switch, and the rung a licensee is standing on determines exactly what it costs to get back to work. Active means registered with a broker and performing brokerage services. Voluntarily inactive means she stayed current but simply did not register. Involuntarily inactive means a renewal or education requirement lapsed. Null and void means the license no longer exists at all. Florida scales the remedy to how long the lapse lasted. 12 months or less requires 14 hours of continuing education. 12 to 24 months requires 28 hours of commission-prescribed education. And at 24 months, the license becomes null and void with no reactivation possible. The logic is about how quickly material goes stale. 14 hours covers one renewal cycle, appropriate for a single missed deadline, while 28 hours covers roughly 2 cycles, for someone who has been out long enough that statutory amendments and rule changes have moved underneath her. One rule holds at every rung: anything other than active status forbids performing licensed services, and commissions earned during that time may be uncollectible. Strikingly, a new associate who misses her 45 hours of post-licensure education faces immediate voidance, no tiers at all, because Florida is more forgiving of proven experience than of an untested newcomer. Question 49. A broker in Pensacola is found to have violated several provisions of the license law in a single disciplinary case. Her attorney explains the maximum administrative fine the commission is authorized to impose for each separate count. What is that maximum? Your options are A. $1,000, B. $2,500, C. $5,000, D. $10,000. Which one is it? Pause the video if you need more time. The correct answer is C, $5,000. C is correct because the commission may impose an administrative fine of up to $5,000 for each count or separate offense, in any combination with probation, suspension, revocation, or a reprimand. Section 47525 Florida Statutes. A is wrong because a ceiling that low would leave the commission almost no room to match a penalty to serious misconduct, such as escrow theft or repeated fraud. So the statute sets a higher limit. B is wrong because $2,500 appears nowhere in the disciplinary provisions of the license law, and no rule adopts it as an outer limit on administrative fines the commission may impose. D is wrong because $10,000 overstates the statutory ceiling for a single count. Several counts charged together can add up to a large total, but each one is capped at the lower figure. $5,000 is the maximum fine per count, not per case. Charge 6 violations in one proceeding, and the exposure becomes $30,000, because the statute multiplies rather than caps. A fine is only one tool. The commission can also issue a reprimand, place a license on probation, suspend it for up to 10 years, or revoke it permanently. And a single final order can stack several of these together. Published guidelines assign a usual range to each violation, which is why similar cases get similar outcomes. But aggravating or mitigating factors like consumer harm, repeated conduct, disciplinary history, restitution, and the number of counts can push a penalty above or below that range. A single act can trigger 3 separate tracks at once: administrative discipline from the commission affecting the license, civil liability from a lawsuit producing a money judgment, and criminal prosecution from the state. An acquittal in one track resolves nothing in the others, since each uses a different standard of proof. The ceiling is per count, not per case, and it can combine with probation, suspension, or revocation in any way the commission finds appropriate. Question 50. A couple who bought a home in Ocala last year established permanent residency there and filed for the Homestead Exemption with the county property appraiser. How does the base exemption apply to the taxes levied against their property each year? Your options are: A. It applies only to school district levies. B. It applies to all taxing levies. C. It exempts half of the assessed value. D. It applies only after owners turn 65. Take a second. Which answer would you pick? The correct answer is B. It applies to all taxing levies. B is correct because the base homestead exemption removes the first $25,000 of assessed value from every taxing levy, and an additional exemption reaches a higher band for non-school levies. Section 196.031 Florida Statutes. A is wrong because the opposite is true of the additional exemption. which is the one that excludes school levies. The base exemption is the piece that applies to every levy assessed against the property. C is wrong because no percentage exemption exists anywhere in Florida's homestead scheme. The relief is expressed in fixed dollars of assessed value rather than as a share of whatever the home is worth. D is wrong because age matters only for a local option exemption that counties and cities may choose to adopt for older residents. The base homestead exemption carries no age requirement of any kind. Florida's homestead protections come in two entirely different forms that share a name but do completely different jobs. The tax exemption lowers assessed value for property tax purposes. The constitutional protection shields the home from forced sale by creditors and restricts how it can be devised when a spouse or minor child survives. The exemption works in bands, not one flat number. The first $25,000 is exempt from everything. The next $25,000 gets no exemption at all. And the third $25,000 escapes every levy except school taxes. The constitutional shield has no dollar limit at all. It's bounded by area instead, half an acre in a city, or up to 160 acres outside one, with only 3 narrow exceptions: voluntary mortgages, property taxes, and construction liens. When a question asks about the base exemption, remember it applies everywhere, school taxes included. It's the additional exemption that carves out school levies, and swapping the two is exactly the trap test writer set. And that brings our full mixed practice session to a close. If you'd like to review everything we covered today, check out the website linked below. You'll find hundreds of free practice questions and complete, easy-to-follow study guides covering all the material. It's all organized and ready, so whenever you need extra practice, it's waiting right there for you. Hit subscribe for our next set of questions, and good luck on your Florida Real Estate Sales Associate exam.